The Institute of Race Relations is preparing to challenge the Expropriation Act in court. A recently signed law allows for expropriation without compensation on an open-ended range of circumstances. To discuss this further now, we're joined by the IRR's Gabriel Kraus, who joins us from Cape Town this morning. Gabriel, thanks for your time this morning. Now, we understand that the IRR has a legal bone to pick on what you call the procedural flaws in the run-up to the president's signing of the act. So on what legal basis is the IRR planning on contesting it in court?
So if we can talk about the procedure and the merits. On the procedure, I think it's very important to note that every law in South Africa is supposed to be based on something like a socioeconomic impact assessment. That is to say, the government is supposed to say, we want to make this new set of rules that everyone has to live under, and this is the impact that we think it's going to have. This is the data that we think, the evidence that we think justifies this, and what are the prospects. Now, the state never really did that properly at all. The land audit in 2017 was fundamentally flawed. It only identified the racial classification of a third of the surface area and then touted those data out as if it covered the whole spectrum. But what's more, the impact assessment is hugely out of date. It goes back to before COVID, before the further job losses, further economic tensions that we've seen, and that's a big problem. On the merits, there are a few other problems, but that's the headline one. On the merits, the biggest problem is the nil compensation clause, in particular for cases where people have vacant land primarily held for the purpose of selling it for a profit.